Good afternoon, guys. My name is Tushar, and I'm working in Lexis and Company as a legal intern. And I'm here to present a topic which is mutual consent and what is the process of mutual divorce. So, firstly, I'll discuss you about what is mutual divorce. So, while the concept of divorce was met with criticism in the past, the time are changing in India. Women no longer feel the need to stay in an unhappy marriage for the sake of society. Therefore, we see more and more couples agreeing to split into amicable term, which was something you heard of before. But many women around the countries are still unsure of how divorce work in India. So here's look at everything you need to know about the procedures of mutual divorce in India. So, first of all, what is mutual consent divorce? At the same suggest a mutual consent divorce is when both the husband and the wife wants to terminate the marriage. It is a decision taken by the mutual consent, and hence the process is a lot smoother than divorce by other means. As per the Hindu Marriage Act 1955, both spouses have the right to file for the dissolution of their marriage. Furthermore, the act also allows both parties to file for a mutual consent divorce together. Now, what conditions to file for a mutual divorce? What is the conditions to file? If you know the answer, can you please comment down the conditions to file a mutual divorce? Because everyone has a different point of view. So please comment down the answer. So I was talking about conditions to file for a mutual divorce. So as per section 13B of the Hindu Marriage Act 1955, the following must be met to file for a mutual divorce. The first one is both spouse must live separately for at least 1 year. Both spouse feel that they can live together. Both the husband and wife mutually agree that their marriage has collapsed. And the last one is both parties agree to compile and file jointly for a mutual divorce without any undue influence, bribe, or fraud. Now, this is the very important things to consider for a mutual divorce. The first one is need for alimony and the amount of alimony to be paid, child custody matters, maintenance of shared property, splitting of properties and assets the couple own. These things are very important to consider for a mutual divorce because this questions always arises after the divorce, that need for the alimony and child custody matters always arise if the children is there, maintenance of shared property. So these are the very important things to remember for the considered for a mutual divorce. Now, what are the different laws regarding divorce in India? So, first one is for Hindus, Jain, Buddhist, and Sikhs. Hindu Marriage Act 1955. For the Hindus, Jain, Buddhist, and Sikhs, these act are mentioned Hindu Marriage Act 1955. For the Christian peoples, the Indian Christian Marriage Act 1872, and also the Indian Divorce Act 1869. Now, for the Muslim peoples, the Personal Law of Divorce, the Dissolution of Marriage Act 1939, and the Muslim Women Protection of Right on Divorce Act 1986. So these are the laws for Hindus, for Christian, for Muslim, and for the Parsis people, the Parsis Marriage Divorce Act 1936. And the last one is the inter-religion or inter-caste marriage. These marriages also, this act is also called Special Marriage Act 1954. So now, the main question is what is the procedures of mutual divorce in India, how courts deal with the mutual divorce, how to file a divorce petition. Now, court hearing and inspection, statement record, what would happen in the first motion and the second motion. So I will be talking about these things in the procedures of mutual divorce in India. So basically, step one is filing a divorce petition, and the second one is also like second one is a court hearing and inspection. The third one is a statement record, and the fourth and fifth step is first motion, and fifth step is second motion, and the final hearing. Now the divorce decree. This is the last step. So I would be discussing these steps for these steps involved in the mutual divorce procedure in India. So the mutual divorce procedure begins with the filing a divorce petitions, which may be filed at any of the following places: court where the couple last lived, court where the couple's marriage was solemnized, the court in the area where the wife currently resides. So, the divorce petition must be filed jointly by the concerned party, and the notice is served to the family court by both parties. The ground for divorce is that the spouses feel they cannot live with each other anymore, and hence have agreed mutually to dissolve their marriage. Another common ground used to get a mutual divorce is that due to unavoidable differences. The couple has been living separately for over a year. The joint petition must be signed by both parties involved. Now, the second step is court hearing and inspections. After the first steps, both the parties will have to appear in the family court with their respective lawyer. The court will go over the petitions and all the supporting documents presented as a proof before the court. It can also try to be reconciliation, and if this is not possible, the mutual divorce procedures continues. Now the third step is statement record. The statement record by the both the parties after the petition. If the court passes an order to record the parties' statements on oath, the fourth step is the first motion. After the recording their statements, the court passes the first motion. Following this, the couple has to wait for 6 months before they can file a second motion. However, second motion must be submitted at least before 18 months after passing the first motion. The first motion, the couple how many months has to wait? 6 months. Then they submit the second motion at least before 18 months after the passing the first motion. Now, what would be happen in the second motion and the final hearing? So once they decided to file the second motion must be submitted at least before 18 months after passing the first motion, so they can go ahead with the final hearing before the court. The final hearing includes both the parties stating their cases and the court recording their statement on oath in the family court. Also, recently, the Supreme Court finds that the 6 month interim period can avoid if the court wishes it to be. So, court do so if they feel both parties are sure about their divorce, and also if there are no issue related to alimony, child custody, or property, which are the very important part for having a mutual divorce, very important conditions. So now the final step and the last step is divorce decree, in which once the couple state that they do not have any differences in matters concerning alimony, child custody, or sharing of property, the mutual divorce proceeds reaches the final stage. Therefore, the couple must reach an agreement for the court to take a final decision. With the court's satisfaction, it passes a decree of divorce which declares that marriage is dissolved and this makes the divorce final. Now, there is a the Muslim are governed by personal law of divorce and also the Dissolution of Marriage Act and the Muslim Women Protect Protection of Right on Divorce Act. Similarly, Parsis are governed by Parsis Marriage Act. Apart from above laws, other marriage are governed by the Special Marriage Act and also Section 13B, which I have discussed earlier. Now, there is a one case regarding Section 13B Clause A, in which in the Supreme Court in Amardeep Singh versus Harveen Kaur, this case is belong to 2017, has stated that provision of Section 13B Clause 2 is not mandatory but directly directory, because apex court has stated that the court can grant divorce after waiving of 6 month waiting period can being satisfied that the waiting period will only prolong their agony, and that all efforts of conciliation having been futile, the court waiving of the cooling off period will also consider whether the estranged couple has settled all the difference relating to alimony, properties, custody of children, etc. So, Section 14 also provide that no petition for divorce to be presented within 1 year of marriage, provided that court may, upon applicable, made to it in accordance with such rules as may be made by the High Court in the behalf of allow a petitions to be presented before 1 year has elapsed since the date of the marriage on the ground that the case is one of exceptional hardship to the petitioner or of exceptional depravity on the part of the respondent. So, the same facts are those alleged in support of the petition so dismissed. The divorce proceeding can take place by adopting two procedures which are as follows. Mutual divorce is a legal process of separation, and the second one is the contested divorce or the divorce without mutual consent is filed without the prior approval of either of the spouse. Common ground for filing such divorce petition is cruelty, adultery, desertion, conversion, mental disorder, communicable diseases, presumption of death, or in case of renouncing the world. So these are the two common procedures for filing. First one is a mutual divorce, and the contestant divorce or the divorce without mutual. So these are the procedures can take place by adopting two procedures. So I would like to end my topic. So we've discussing in this video what is the process of mutual divorce consents and how many types of proceeding can take place by adopting uh, divorce, mutual divorce and divorce without mutual consent. And also, we are discussing about the laws regarding to divorce, mutual divorce. So that's it. Thank you so much, guys, and please subscribe our channel, Let's Click, and do follow our Instagram page, Facebook page, and LinkedIn page. Thank you so much.